Hey everyone, this is Matt Murphy, and today I'm going to be attempting to briefly answer a question we get a lot from our clients. Do you get to choose your own treating physician when you file a Montana workers' compensation claim? And so the operative statute that we're going to be working with, unfortunately, is Montana Code Annotated 3971-1101, which specifies that prior to an insurer's acceptance of your claim, if you're injured at work, you get to choose your own treating physician. And before I go any further, I would add at this juncture that you most certainly should. You should go to a doctor that you trust and one who you know will do a good job in your claim and who will be able to provide the kind of treatment that you need. So, back to what happens after you file a claim and then the insurer accepts. At that point, technically, according to 1101, the insurer can then redesignate a physician of their choosing if they so choose. When I have seen this, and I have seen it in the past, it's typically a defense medical examiner, an insurance gun for hire. That's not who you want to be designated as your treating physician. The takeaway here is, if you're hurt at work, you do want to seek medical treatment, you want to seek a doctor who you know will do a good job, and you want to do so as soon as possible. That's both to be able to establish care with that physician and also to document your injury. What happened, when it happened, where it happened, all of those factual or pieces of evidence will be important in establishing your claim for benefits. The other interesting item worth discussing when we're talking about 3971-1101 is the constitutionality of that statute. In Montana, we have a high value on the individual right of privacy and personal bodily autonomy and otherwise. In fact, it is most certainly Murphy Law Firm's position that 3971-1101, as currently written, in other words, allowing the insurer to choose your physician, is a violation of your constitutional rights under the Montana Constitution, Article 2, Section 10, which guarantees your right of privacy and personal bodily autonomy. We've challenged this statute. We've never successfully challenged it at the court level. The disputes have resolved before we've gotten a ruling, but it is our belief that Article 2, Section 10 of Montana's Constitution and a number of case laws that reaffirm the strong privacy rights of Montana citizens, something we can all agree is a lovely part of Montana jurisprudence, would invalidate the overreach of the legislature in 2011 when it passed House Bill 334, which codified Montana Code Annotated 3971-1101 and gave insurers, not injured workers, the right to choose physicians. We believe that's a clear privacy invasion and an infringement on all Montanans' ability to protect their privacy and their personal bodily autonomy.